Good morning.
Good morning.
Morning.
We now have the matter of In Re JP, case number C210388. We thank you both for waiting so patiently. And if attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Mary Steer for the state, ready to proceed.
Thank you.
Morning, Your Honor. Andrew Hocklow Finch on behalf of the defendant, ready to proceed.
Thank you. Attorney Steer, would you like to reserve time?
Yes, please. Could I reserve 5 minutes?
Absolutely. Whenever you're ready.
Thank you. Good morning again, Your Honor. Counsel, may it please the court. Unless the court has any questions about, I know we had some supplemental briefing about appealability. Unless you have any further questions about that, I'm going to launch right into the merits of the case. And
first, let's see if there's any questions from the panel with regard to jurisdiction.
I guess I was just curious. I know that your argument is that if you had to wait until the very end, until after disposition of the juvenile, that you wouldn't have any way to exercise the serious youthful offender punishment. And I was just kind of curious as to the procedure that would, if you did have to wait to appeal, what would happen if you won on appeal and it was remanded after there was already a disposition?
I don't think that we would be able to appeal after disposition because I think jeopardy would have attached, so that as far as another indictment, I don't think that we could get another indictment if JP was already adjudicated.
Okay.
That's why I think that we have no.
This is your only option. You have to appeal this at this stage.
Correct.
Okay.
Are there any further questions? All right, so Attorney Steer, if you want to go ahead and go into the merits.
Okay, thank you. And I kind of doubt I'm going to use up much of my time because I think I covered it in my brief. JP was charged in April with a number of charges. The one here is aggravated murder. In June, on June 10th, we indicted her with a serious youthful offender indictment. The juvenile court dismissed it because the court believed that we did not comply with the time guidelines that are in 2152A4. But when you look at the plain language of the statute, 2152A gives the state 4 options for how to proceed to bring us to seek a serious youthful offender disposition. And the first option is by indictment, and that's what the court did. It's separate from any of the other options. So once the state decided to proceed with the indictment, the time guidelines in A4 did not apply. I know that the 8th
Attorney Steyer, if the time guidelines don't apply, how do RC 2152-13A and C1 work together, or do they?
Well, they do. C1 gives the C1 mostly applies, I think, as far as the grand jury part of it, to those cases when the state decides to proceed under A3 or 4, because in those situations, either by giving notice or if we had initially included a serious youthful offender on the initial charge, then there wouldn't have been probable cause found, and so that gives the juvenile the opportunity to seek to have the grand jury find probable cause, rather than, as it says in section B, letting the juvenile court determine whether or not there's probable cause. So I don't think that it necessarily, then the rest of the time, as far as the speedy trial provisions that are in C, that those do apply as soon as as soon as JP was indicted, then the speedy trial provisions started. And
But
then,
under your analysis, in essence, it's almost like the speedy trial would get restarted then.
restarted, well, the speedy
other-
trial only attaches once there's a SYO indictment. Otherwise, there's not a speedy trial provision with respect to the juvenile adjudication
Okay.
and
So
disposition.
then what you're saying in this case is when the initial indictment took place without the SYO, there was no speedy trial. And then,
Correct.
and then the 20 days passed, still no speedy trial. Then the SYO is requested, and at that point, speedy trial begins?
Correct. There was no indictment before she was indicted with the SYO. She was charged, and then so the case was instituted in juvenile court. I think the part of the reason without, the legislature provided these 4 options, and they've been in there for a fairly long time. I think since at least 2002 or so. And I think in part it may be because the state needs options. In this case, when you read the juvenile court's decision, she said that the state was still conducting discovery. And on June 2nd, I believe the state said that after looking at discovery, it appeared that the state was going to need to seek an SYO disposition.
Right, and that happened, I think it was it in April? Am I remembering that correctly?
I'm sorry?
I'm going to go back to my initial question. So I'm looking at 2152.13 C1, and here it talks about speedy trial beginning with when the child is indicted or charged by information.
Correct.
So in
If-
this case, he was charged, is what you're saying, right?
She was charged. She was charged, but she was not charged with an SYO initially. So there was the speedy trial wouldn't start to run until she's indicted.
Well,
So
here it doesn't require for it to be with SYO under subsection A. It says if the child is indicted or charged by information on the date of the filing of the indictment or information.
Well, but those sections apply when a child, it applies when an SYO disposition is sought. If there's no SYO disposition sought, then there's no speedy trial provisions that apply in a juvenile case.
When would the notice requirement in section 4 come into play? Under what circumstances? Because, in this situation, we have a complaint that was filed, no SYO indicated in the complaint, and then an indictment was later obtained. When would section 4 apply?
Well, I think section 4 would apply if the state from the get-go knew, if the state didn't include it in the complaint, but decided early in proceedings that it was going to seek an SYO disposition. That's just another alternative way that the state can proceed. We can do it by serving notice. And that's when juvenile rule 22 would apply as far as the motion. I know that the state cited that the public defender cited that in their brief. That's when those notice requirements would apply.
But why would the state ever proceed under 4? Because the notice then starts the speedy trial, whereas if you'd wait and do what you did in this case, you're saying the speedy trial doesn't start till the indictment. Why would the state decide to ever go under section 4?
I'm not sure that our office does. I'm sorry, I don't know what our juvenile prosecutors do. I think that the legislature provided 4 different ways that the state can seek an SYO disposition. Whether or not some offices may seek it to do it by notice shortly after the first appearance, or in this case where we were waiting. I believe JP filed for a competency report, and so that took some time too. And I think at the same time we were moving forward with our discovery, and it was only after we had really reviewed the file that we realized that we needed to seek an SYO disposition.
And that was mentioned actually at a hearing, right? It just, there was no written notice filed.
Correct, correct. I think that, and I'm not sure that at that point, because we didn't present it, I believe, to the grand jury until, I think it may have been June 8th that we presented it to the grand jury, or that we made the final decision to move forward with the grand jury. And I think that any of these other, all of the protections that are provided for in 215213 then kick in as soon as we get an indictment. I mean, really, in the grand scheme of things, we could have simply dismissed the charges against her and then gone through and indicted her and ended up in the same place where we are now. I think that when you read the plain language of the statute, there's just no requirement that the indictment that's referred to in A1 has to be the first charge against the juvenile. I think that the indictment can come after the juvenile has been charged, and it's just another way that the state can bring an SYO disposition.
Thank you, Attorney Steer.
Unless you have any further questions, I'll just rest on my brief.
Thank you.
Thank you.
Good morning again, Attorney
Morning.
Hopolovich.
May it please the court, my name is Andrew Hockolo Finch, and I represent the defendant appellee, JP. The juvenile court properly dismissed the serious youthful offender indictment in this situation, as the state failed to meet the notice and timing requirements set forth in revised code section 2152.13. The following facts are not in dispute. On April 20th, 2021, an original juvenile court complaint was brought against JP. JP is not subject to a bind over due to JP's age. The state did not file a notice to seek an SYO indictment with the court, noted they serve a notice upon JP. And it wasn't until June 10th, 2021 that the state filed a motion for an SYO indictment with the court. And in response to the state's assertions regarding discovery and that the state was still reviewing the file, this case was charged as an original juvenile court complaint as a murder. JP was the only person charged in this. There was no confusion about the charges or about what they were doing. Discovery is a long process, and there was a lot of evidence and body-worn camera, et cetera, to review here, but this is not a situation in which there is confusion about what the charge should be or who should be charged. And additionally, RC 2152.13 even gives the state an out in situations where there is confusion, and that they can extend the 20-day notice and filing requirement for good cause shown, which is something that the state did not do in this instance. As the court is aware, there is a split circuit in Ohio on what to do in this situation. The 8th District, through its case law of KA and sister case RG, as well as ES and TS, maintain that in instances where original juvenile court complaint is brought without an SYO indictment first, that the state is beholden to the notice and timing requirements. The split comes from a single case in the 12th District, which is in Ray JB, which maintains that the state can file an SYO indictment at any time during the procedural posture of a case. JP is urging this court to follow the 8th District's interpretation, as the interpretation of the 12th District invalidates sections A3, A4, and B of the statute and stands in contradiction to a child's speedy trial rights. As this court noted in its questioning of the appellant, essentially the state's line of argument would allow them to circumvent speedy trial. Court could incarcerate a child for an entire year, and then on day 366, the state could file a SYO indictment under the 12th District's logic, and that wouldn't have been a violation of a child's speedy trial rights. This is analogous to the state running out the clock on speedy trial for an adult indictment and then being able to dismiss that indictment the day before it runs out, refiling it and resetting that. So JP is urging that this court follows the 8th District's interpretation because it's the only interpretation that protects a child's constitutional rights to due process and speedy trial.
What about Ms. Steer's argument, though, that the state could have chosen to just dismiss the complaint and then indict the child later, and we would be in the same position as what they're trying to do here with the SYO indictment?
Your Honor, it's our position that the state could dismiss the original juvenile court complaint and refile that, but that they would not be allowed to file an SYO indictment, that 20-day notice and requirement would be considered as a statute of limitations or analogous to speedy trial in an adult court, where the state can.
Does that say that, or that's just your position?
That's our position and interpretation based on the child's constitutional rights to speedy trial and analogizing it to an adult situation in which the state can't run the speedy trial clock, dismiss the indictment, and then refile to reset the speedy trial clock.
In this case, if there's a complaint filed with no SYO, there would not be a speedy trial clock running, right?
There would not, Your Honor, but they would be beholden to the 20-day notice and filing requirement set forth in A4. It's JP's assertion that the plain language of the statute maintains that when the state does not seek an indictment first, and when the state does not seek a notice to obtain an indictment in the original juvenile court complaint, that they have 20 days from the filing of the original complaint. So if the state were
From the original complaint. So if the
Correct.
original complaint's dismissed, you're still saying they're beholden to the 20 days from the date of that complaint.
Correct, Your Honor, because to interpret it otherwise would allow the state to circumvent speedy trial rights. The state is allowed to dismiss original juvenile court complaints without SYO indictments and refile as many times as they wish. So allowing them to reset that 20-day clock each time would also allow them to continue to circumvent speedy trial rights of the child as well. So, Your Honors, if there are no further questions, JP maintains that this court should follow the interpretation of the 8th District. It is the only interpretation that maintains a consistent internal logic and upholds the entirety of the statute. And that if the legislature's intended the state to be able to seek an SYO at any time, they would not have included those specific provisions, nor would they have amended Juvenile Rules of Procedure 22 and 29 to conform to the notice and filing requirements. And therefore, JP respectfully requests that this court affirm the juvenile court's decision to dismiss the SYO indictment. Thank you.
Thank you for your argument, Attorney Hogala-Finch. Attorney Steer?
Thank you, Your Honor. I would just emphasize that a lot of what the 8th District, the way that it reads the statute, and then I think also the way that JP is reading the statute adds a lot of words that simply are not there. And while there may be some reasons for wanting to change what's written in the statute, that's a job for the legislature rather than for the court to try to read different words into the statute. The legislature, for whatever reason, has provided 4 different ways for the court, for the state to move forward with an SYO indictment. And if the state opts for, as we did here, A1, to move under A1, then the rules under A4 simply do not apply. As far as the speedy trial, there's no speedy trial provisions that attach until there's an indictment or until there's notice given of this SYO an SYO disposition that we're seeking one. And so to say that we're trying to run out the clock on speedy trial, it's just simply not happening because there's no speedy trial provision until we get an indictment. And with that, we would just ask that the court reverse the dismissal of the indictment. Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Have a great afternoon.
Thank you, Your Honors.
You too.
Thank you.